Hi, for today's presentation, we're going to be presenting on Students for Fair Admission v. Harvard, and the year is 2023. First, let's go over the background of the case. Students for Fair Admission, or SFFA, filed a lawsuit against Harvard University. Their main argument was that Harvard's admission process was unfair, specifically toward Asian American applicants. They claimed that Harvard gave Asian American students lower personal ratings, which included things like personality and likability, even when their academic achievements were strong. Additionally, SFFA argued that Harvard was using race in its admission process in a way that effectively limited how many Asian American students could be admitted. This case raised major questions about whether considering race in college admissions is fair or discriminatory. Rithwik, get off your phone. Question number 1. Why did Students for Fair Admission sue Harvard University? A. Unfairly disadvantaged Asian American applicants. B. Unfairly disadvantaged Latino applicants. C. Fairly gave every applicant a chance. D. Unfairly disadvantaged African American applicants. The correct answer is A. Unfairly disadvantaged Asian American applicants.
Moving on to the argument of the petitioner, Students for Fair Admission claimed that Harvard violated Title IV of the Civil Rights Act of 1964, which stated that public schools and higher education institutions were prohibited from any form of discrimination. They said that Harvard favored underrepresented minority applicants over anyone else. They also claimed that Harvard violated the Equal Protection Clause of the 14th Amendment, which protected anyone from discrimination based on race. This showed how they failed the strict scrutiny standard because the courts found that the program failed because of its diversity goals that were not measurable, and this led to negative impact on Asian American applicants, who also showed a stronger academic qualifications compared to anyone else. They argue that there could be other factors that could be taken into consideration, like economy, their geographic background, and academic performance that can be replaced over race. Question number 2. Which best summarizes the petitioner's overall argument? A. Harvard should control admissions fully. B. Race should never be considered in any decision. C. Harvard's use of race violates equality and federal law. D. Diversity is not important in education. The answer is C. Harvard's use of race violates equality and federal law. With that, Harvard argues that its admission process followed established legal guidelines for considering race. Based off the Supreme Court case Grutter v. Bollinger, it allowed colleges to consider race as one factor among many in order to promote diversity. Harvard claims they did not use quotas, but instead evaluated each applicant thoroughly. They also argue that removing race as a factor would significantly reduce diversity on campus. Their goal, according to this argument, is to avoid a sharp decline in the enrollment of underrepresented minority students. Additionally, students that are tentatively admitted go through a final stage of the Harvard process called the LOP. With that, students who are considered to be cut go through a stage of a LOP list, where there are 4 pieces of information taken into consideration: legacy status, recruited athlete status, financial aid eligibility, and race. This shows how overall there are different factors taken into consideration other than race in their application process.
Question 3. What court case did Harvard use to back up their argument? A. Brown v. Board. B. University of California Regents v. Bakke. C. Tinker v. Des Moines. Or D. Grutter v. Bollinger. The answer is D. Grutter v. Bollinger. The court ruled 6-3 that race-based affirmative action in college admissions is unconstitutional. The majority opinion was written by Chief Justice John Roberts. He argued that using race in admissions violates the Equal Protection Clause of the 14th Amendment. The court said colleges cannot use race as a deciding factor because it does not treat applicants as individuals and lacks clear limits. However, the ruling does allow students to discuss race in their essays as part of their personal experiences. Overall, this decision effectively ends affirmative action in both public and private colleges across the United States.
What is the ruling of the court case? A. 8-1, B. 3-6, C. 4-5, D. 6-3. The answer is D. 6-3.
Now, why does this case matter? It allows us to understand how the court interprets the Equal Protection Clause, which is individuals being treated equally. It shows how the court interpretation changes over time. In education, that affirmative action is unconstitutional, and changes the decision from Regents v. Bakke, where affirmative action is allowed but not quotas. It shows a shift in public policy, and it rules that schools can't directly consider race as a factor for admissions and allow students to have access to elite education without worrying about affirmative action and giving them more opportunities for their learning.